Ladies and gentlemen, my name is Keith Raines. I'm a circuit court judge for Washington County. In a few moments, you'll be appearing in front of a judge to apply for a protective order. We handle Family Abuse Prevention Act restraining order applications at the same time as elder and disabled persons because the procedures are very similar. The most significant difference between them is the Family Abuse Restraining Order requires a showing of physical abuse or threat of imminent physical harm, whereas a restraining order for elder or disabled persons only requires a showing of mental abuse, theft, or a number of lesser reasons. The purpose of a family abuse prevention restraining order is to prevent future physical abuse or the threat of imminent physical harm. Sometimes people have been sent here even by a police agency because the other person has been mentally abusive, has improperly threatened to take children, or even been very mean. While all those things are inappropriate, they may not be a proper basis for a family abuse restraining order. The restraining order has a 1-year life. It can be renewed if necessary for 1 year at a time, but you must renew it before it expires. The restraining order can be enforced only after it's been served or delivered to the other person, and the sheriff's computer shows it's been served. We strongly prefer the sheriff does the service. It is possible to use a third-party person to do service, but then that person must sign the proper affidavit, deliver it to the sheriff, and get it entered in the computer. That increases the chance that this step could be missed, so we prefer to use the sheriff. Some of you may not know where the other person is, and we'll be giving an extra copy of the document, so if that other person comes around, the police agency you call to help can do the service at the same time and can enforce the order. The restraining order is the court's order. It does not belong to the petitioner. The petitioner does not get to decide when it applies and when it doesn't. If the respondent disobeys the court order, he or she will go to jail. And all too often, a car is stopped and both parties are in the same car. Petitioner says something like, the baby was sick and we have a doctor's appointment, my car wouldn't start, I didn't know who to call. The other party is the other parent who needs to know what the doctor says. What happens is the respondent is taken to jail, usually for about 2 weeks, just long enough to lose employment, housing, and disrupt everyone's life. Do not invite the other person to disobey the restraining order. If there's something not working in the restraining order, we can change it. Typical things that we may review include if you want to go to counseling to work on the relationship with the other person, or the parenting plan should change, or there's a school or community or family event where you'd be safe if both of you attended. Sometimes people want no contact at all first, find they need to be able to speak by phone or through email to resolve parenting or other issues. When you come in for a modification, we'll do your case first. You don't have to wait as long. We're not trying to rule your life, we just want to make sure you're safe. A surprising number of people ask the court to dismiss their own restraining order. We look at these requests very carefully. If there's a contempt or a criminal case pending, we'll not dismiss the restraining order. If the restraining order was recently issued, we'll probably not dismiss that either. It can be a hardship even for a petitioner to have a restraining order. If they're small children, there's suddenly no help, no extra hands, there's no money. Some people feel guilty about having a restraining order and start to tell themselves, well, maybe if I just hadn't said that one thing, this bad thing wouldn't have happened to me. Well, while it's nice to have extra help and to have money and to feel good about yourself, none of those things really matter if you aren't safe. So when someone asks me for a dismissal of the restraining order, I want to know 2 things. How has the other person changed, and how do you know it? Not what the other person has promised or started to do, not what some court has ordered that person to do. Rather, what counseling program has that person completed to assure that he or she will respond differently when the stress of life overtakes him or her. If it's information from the other person's mom or best friend, that's just not good enough. You need to talk to the professional who's worked with that person to get assurance that you're no longer in danger. The other person can sign a release so the professional can let you know what's going on. Some folks say the restraining order works so well they don't need it anymore. Well, restraining order is like medicine. You don't stop taking medicine because it works. You have to make sure the underlying problem is fully taken care of. If you have a child with the other person, there's a custody order in place. This process is unlikely to change that order. Please go to the court that issued the order and get the change there. If there's not a custody order in place, we are likely to create one here. The legislature has instructed us that a child has a right to a relationship with both parents, even if one's a crumb. So we need to figure out how the child can be safe and comfortable during parenting time, but also how the other parent can feel comfortable exercising parenting time. If you think that supervised parenting time is necessary, you'll need to propose the name of a supervisor who should be somebody the child knows and is comfortable with, and someone who doesn't have an agenda against the respondent. The court and the state have no resources for supervision. Please make sure the supervisor is willing and able to serve and is available. A restraining order has an impact past just what the document says. While the restraining order may keep the other person away, move that person out of his or her home, award custody or parenting time, there are other consequences. When the other person goes to rent their new place, he or she is probably going to have to pay a fee to the landlord to get checked out. These restraining orders show up. Most landlords won't rent to a person with a restraining order. They figure this is a problem person who will kick doors, break windows, and poke holes in walls. Most prospective employers are checking out new hires very carefully. Most employers won't hire somebody who has a restraining order against him or her. And some employers have a policy of terminating any employee who has a restraining order against him or her, and there is no remedy under Oregon law. I tell you this so you're not surprised by unintended consequences. The other person has a right to contest the restraining order, and the timing works like this. The other person gets a copy of the paperwork, and that person has 30 days to make a decision to ask for a hearing. And all they have to do is to write to the court or stop by the courthouse to get a hearing date. These hearings come up very rapidly, within 3 days of the request in many cases. If you don't attend the hearing, the restraining order will be dismissed. So make sure you've given the court a good telephone number and address where the other person cannot take your mail or change your delivery. If you use a third party, make sure that person's going to be around and check your mail frequently. Tell your employer and your witnesses you may have to appear in court with very little notice so they can be prepared. Get ready for a hearing now. It's a good idea to consult with a lawyer even if you can't hire one. In these hearings, often the court hears one party say one thing and the other deny it or claim to be the victim. It can leave a judge wondering what is going on. Is anybody telling the truth? So if you can, bring extra evidence with you. If there's another adult witness to what happened, have that person come to court. If you're injured, bring photos of the injury. Well, maybe you waited too long to take pictures, but you showed the injury to someone. Have that person come to court with you. If the police took pictures, they have them. It may be hard to get them. So take your own pictures, a whole roll under different lighting situations. Bring the very best ones to court. Please print out any digital photographs rather than leaving them on your cell phone or camera. That way the photographs can be offered into evidence. Your witnesses must come to court with you. The court will not consider a written statement even if it's notarized. It is possible to use telephone testimony for a witness who just can't come to court. The technology is pretty good, but the problem with telephone testimony, it's so hard for the court to make a credibility determination of a telephone witness. We rely so heavily on body language for communication. Telephone testimony is better than none, but personal testimony is much, much better. We know the witnesses don't want to come to court. They don't have time. They don't want to be in the middle. They don't want to get involved. If you need to have somebody appear in court for you, the court will issue a subpoena for you. It commands the person to appear. It requires their employer and school to let them come without any penalty. And a subpoena is a document that you can serve yourself. Please remember the court does not investigate cases. It only considers the proper evidence presented by the parties. The relief that we allow today is only temporary in nature. If you need more permanent resolution to issues like custody or parenting time, paternity, divorce, you must file another action. I recommend you consult with an attorney to learn what would be best for you. The folks at the Advocate's Office, the Family Law Office, will all try to be helpful, but none of them can recommend a course of action or give you legal advice. Only a lawyer can do that. Well, many people tell us they can't afford to hire a lawyer. But there are a number of lawyers who provide what's called unbundled legal services. Well, they'll give advice, review paperwork that you've prepared to make sure that it does what you want. And I urge you to take advantage of that service if that's the best you can do. If you mess up the papers, a lawyer may not be able to fix them later on. The advocates will bring you to the courtroom now to complete the paperwork. When the judge calls your name, please come up to the table to be sworn and stand behind one of the black microphones. Everything you say will be recorded. We call that being on the record. When you're finished, return to the advocate's office. They'll help you get photocopies, a case number, and get you on your way. Thanks for your attention.